Now, the ace criminal defense attorney who represented Michael Jackson the first time around in 1993 on charges that were hauntingly similar, Howard Weitzman, joins us from Los Angeles. Howard, are they not? First of all, welcome. Nice to see you again.
Thank you, Geraldo.
Okay, so did you have a sense of deja vu when you heard of the arrest, the complaint this time around?
Well, I did. Remember the last time there was no arrest, there was no complaint, there was a civil suit filed. So it was a bit different, but we dealt with the same district attorney, Tom Sneddon, appropriately nicknamed Mad Dog, by the way.
So you believe that he really has it out for your former client, for Michael Jackson?
Well, I think he has a state of mind that Michael has committed criminal acts and that Michael slipped away the last time and he's going to get him this time. So clearly there's an attempt at a show of power here.
Is it just a show of power, or is it revenge? Do you think he has an axe to grind? He wants to. He's en route to retire soon. He has this guy who got away 10 years ago. Do you think he's got something more insidious than just an axe to grind?
Well, I think subconsciously he wants to show both Michael and the world that he's in control. What's very different here from the last time is Michael's in the criminal justice system now, and that has caused and will continue to cause him a lot of problems. He's not in control. He's in somebody else's jurisdiction. And I think a lot of what has gone on has been the result of either poor planning or bad advice, as I see it.
Let me ask you something more substantive than that before I address some of those issues that you raise, Howard. Do you believe that your former client is a child molester? Do you think he's a pedophile?
No, I do not. But the bottom line, I wasn't there in 1993. I wasn't there in 2003. I don't know what happened. But I choose to believe he's not a pedophile. I choose to believe he has not molested children. And I hope I'm right.
Then why did he pay all that money to evade the charges last time around?
Well, you're talking to someone who didn't agree with what ultimately happened. You have a team, the client makes the decision for whatever reason, sometimes just to avoid having to go through the risk of a trial, because it's always a risk when you're in the criminal justice system. I wish it hadn't happened. I said that back then, and I say it today. But that's history, and now he's got to deal with 2004.
Under the law as currently written, as you know, Howard, that previous complainant might turn up again and testify against him in the criminal court.
Well, as I say, I felt 10 years ago it was a case that could be tried and won. I feel today if that person surfaces again, the lawyers, if they're well prepared and do their job, will be able to dissuade people that the offense took place. Wait and see what happens.
What do you think about the fact that the current complainant also hired the same attorney, Larry Feldman, who got the big score last time?
Well, you know what? It says something there. If he hired Larry, the leverage, if you're looking for money in a case like this, is before you go to the authorities, not afterwards. It seems to me it's an indicator that the case is weak. And if you look at the allegations here, meet cancer victim, vulnerable young man, invite him back to Neverland, give him wine and molest him, doesn't make a whole lot of sense.
Well, I may agree with you on that point, Howard. What do you think of the mistakes you mentioned by the defense team this time around? The arraignment, for example.
I have to say, first of all, Michael, although he is smart and understands a lot of what goes on around him, he's not easy to control. First of all, to be late for the arraignment in your first court appearance is just something that shouldn't be done. The judge controls that environment. It was a show of disrespect. If he had to leave at 6:30 a.m., should have been there on time, and I'm sure will be there on time going forward. I would have preferred he not show up in a limousine, just an SUV. I would have preferred that it was less of a spectacle and he went directly to the courtroom. All of that. And the conduct coming out, I thought was the wrong message. Ultimately, there's going to be jurors, 12 people, some who may or may not have Thriller or Bad in their record collection, who may look at Michael as unique and eccentric, although a great creative talent. And somebody has to impress upon Mike that he's going to be playing to an audience that may not include 12 fans. Maybe some fans and some people who don't like the music or don't like the way he's conducted himself.
Love to talk to you all night, mate. Howard Weitzman, thank you very much.
Michael Jackson is not a pedophile. He's never been a pedophile. The prosecution has spent years trying to put together a story which they hoped they could prove and failed to prove. Michael Jackson is not a pedophile. He's never molested a child, nor would he ever even conceive of doing such a thing.
We just heard this attorney Pirro and defense attorney Lefcourt having this argument about the quote-unquote personal stake of Tom Sneddon, the district attorney. How common or uncommon is it to have the district attorney removed from the case for having an alleged axe to grind?
Or the appearance of an axe.
It's not likely that he's going to be removed for the appearance of an axe to grind, although ethically, of course, if there is, I suppose, a question about improprieties in terms of this, perhaps ethically there's an issue as to whether he should be removed. But it's unlikely to see him be removed but in terms of an actual conflict. I haven't seen anything yet that suggests a conflict. The only conflict they might be able to establish, if such a thing occurred, is that he's done something unethical in his pursuit. For example, one of the issues brought up in court on Friday that's gotten very little press is the fact that the next appearance on February 13th is going to deal with a search of, allegedly, the defense attorney's investigator's office, authorized by the district attorney, in which confidential, according to the defense in court, a confidential attorney-client privilege work product was taken by the district attorney from the defense camp.
That's illegal. You can't do
well, that. Now, that's an interesting question. If that's why we're going to have a closed-door, in-chambers hearing on February 13th, which is primarily what's going to happen that day, in which the defense is going to argue, that's exactly what the district attorney did. If they can show that, then you got a chance of getting the district attorney out of the case.
Are you saying, as you sit there tonight, that investigators for the district attorney's office raided the offices of a defense investigator and seized his files?
That was basically what Mark Garagos said in court on Friday.
Now, there may be missing files, but is there certain knowledge that the files were taken by the authorities?
Yeah, the files were allegedly taken by authorities. They're being kept by, I don't know whether they're still in the district attorney's possession, the police possession, where they are exactly. But that is the reason why Mark Garagos wants an in-camera hearing, a closed-door judge hearing, without the press, without the public there. And the reason is he is claiming, I can't vouch for whether he's right or not, of course. I'm just saying this is what happened in court on Friday. He is making an argument that confidential privileged information was taken.
That the DA did this without a search warrant, that the DA burglarized it? Okay, what are you saying?
I don't know whether they had a search warrant or not. I believe they had a search warrant.
The search warrant is the absolute entree into a place to get evidence. It's signed by a judge.
And I'm not, by the way, agree. I have no independent knowledge of whether Mark Garagos is correct or not. I'm just saying, if it is proven that Mark Garagos is correct, that in fact privileged information was seized from basically a defense employee, then I'm answering Geraldo's question, then you've got a chance that perhaps a district attorney could be removed from the case on the grounds that he's overstepped his authority. I have no idea whether it's true or not. I'm just saying this is part of the story that's gotten very little press. That's what's going to be argued on the 13th, although we may never learn the answer of it, at least in soon after that, because it's going to be behind closed doors. Garagos' argument being, it may reveal confidential information that my investigators had, so I want it behind closed doors.